We've discussed in general that crimes require both an action called an actus reus and a mental state or a mens rea, and that should make sense. Blameworthiness requires that we prove defendant had a criminal mens rea accompanying the action. Criminal mens rea demonstrates the blameworthiness because it means that defendant had a choice whether to commit the crime or not, and our defendant chose to commit it. Now I want to focus on crimes that don't require a criminal mens rea. We call them strict liability crimes. These are decidedly rare in the law because we expect culpability to come from a bad mental state and not just from an act. Strict liability crimes are a distinct departure from this foundational premise. Strict liability crimes require that a prosecutor only prove the act that's the subject of the statute. The mental state of the defendant becomes irrelevant. Generally, strict liability crimes involve misdemeanors and infractions, small wrongs where the law decides, you know what, it's not worth the state's time to conduct a full-blown trial and prove a mental state. Perhaps you got a speeding ticket and you want to argue that you didn't intend to speed. You thought you weren't speeding, or the speedometer was broken. Guess what? Too bad. You sped, and therefore you committed the infraction. That's a strict liability crime. Here, I want to discuss the most serious of the strict liability crimes. It's called statutory rape. If defendant's convicted, it often carries a prison sentence, and in most states, it carries the requirement that the defendant has to register as a sex offender. 20 years, 30 years, sometimes for life. Statutory rape has to be distinguished from rape. Statutory rape is about presumptions regarding consent. It's where the state has determined that voluntary sexual intercourse between two parties is presumed to be without consent because of the age of at least one of the parties. In statutory rape, the state has already decided that an underage person is incapable of consenting to sexual intercourse. That's true even if the facts show that the youth consented. Indeed, in some statutory rape cases, the underage person wants to testify that the act was consensual. Doesn't matter, because it's all about a conclusive presumption that it wasn't consensual, and that's all tied to the age of the victim. At its core is a strict liability crime. What does a prosecution have to prove? Well, it's quite simple. The prosecution has to prove that the defendant had sexual intercourse with a person who's under a specified age and who, because of that age, is presumed incapable of consenting to that intercourse. That's the actus reus of this crime. Notice that in my definition, there's no mens rea listed. No requirement that the defendant intended to have sex with someone underage, or that our defendant was reckless in figuring out whether the victim was underage. Strictly about the action. Now, it's within the state's province to place the parameters on any crime. Therefore, it's interesting to note that every state has a different age of consent for statutory rape. Around the country, the average age of consent is 16 years old. Although there are states where the age of consent is 18, anything below 18 is unlawful, and there's a couple of states on the other end of the age spectrum where the age of consent is 14 or 15. Because it's based upon age, this makes statutory rape a different crime from rape, which is based on a lack of consent from external, extrinsic reasons, extrinsic factors. Instead, statutory rape is a crime of sex because of the age, where the state has decided ahead of time the age it wants to count as its age of consent. For more than a decade, my scholarship has been on the topic of sex crimes and sex offender registration laws. I've read hundreds of cases, and many of those cases involve what appears to be willing victims. But the crime of statutory rape ignores the consent of the party, the actual consent of the party, for a perceived higher good. There are certain policies that are driving this crime. What do you think they might be? Well, first is the basic belief that underage people shouldn't be engaged in intercourse. That goes back to our notions of morality, that in the eyes of the criminal law and way back from the time of common law, sex began as an activity only between married people. Additionally, the resulting unwanted pregnancies from these encounters exact a cost. They exact a human cost and they exact a financial cost. It's a cost to the people involved, and it's a cost to the state who may end up taking care of these unwanted babies. Finally, we need to acknowledge that statutory rape often includes measure of power or the exertion of control. That too is part and parcel of this crime. so inherent in a sexual relationship between a 35-year-old teacher and even a consenting, and I put it in quotes, even a consenting 15-year-old are often issues of subtle coercion. Sometimes in a situation, the prosecutor is going to charge the defendant with both rape and statutory rape. That might be a situation where the prosecutor is not sure that the jury is going to agree with the facts that support the rape, but the victim's underage. And so the prosecution charges with both rape and statutory rape. Although originally only males could be convicted of statutory rape, all laws today are gender neutral. That means that both boys and girls can be victims, and both men and women can be defendants. Most state codes today have built-in age differentials, like we see in Maryland in the case of People v. Garnett. Sometimes it's in a tiered formulation. Within a certain age range, no crime or only an infraction. Maybe it's 19 down to 15. Then the further out you get, more than 4 years separating, it turns into a felony. I want to introduce you to some of the faces of statutory rape. I want you to imagine two high school students, both under the age of consent, who engage in sex with each other. In one study a few years ago, respondents reported that their average age of their first encounter was 15 years old. That's below the age of consent in nearly all the states in the country. So what's a legislature supposed to do when it recognizes that people aren't following the law? That we have underage people engaging in sexual intercourse all across the country. Seems like statutory rape laws aren't really working. Here's what they did. To avoid punishing severely two high school sweethearts, some states have created Romeo and Juliet laws, that's what we call them, where they do not punish peer-on-peer underage sex. Female statutory rapists have surfaced in the last couple of decades. They have begun to occupy the limelight. These are teachers, nurses, moms of friends who are convicted of statutory rape for having engaged in sexual activities with underage males. Another face of statutory rape captured the public's attention was a 19-year-old young man named Zach Anderson. Zach traveled across state lines from Indiana to Michigan to meet and have sex with a girl he thought was 17 years old. Now, had she been 17, this consensual sexual encounter would have been legal because that was the age of consent in Michigan. But she lied to Zach. The girl was only 14 years old, and because of that, their sexual intercourse was illegal. Here's the impact of statutory rape being a strict liability crime in Michigan. Zach couldn't go into court and say he didn't have a criminal mens rea, he wasn't blameworthy. He couldn't say he thought she was 17. She couldn't go into court and say she lied. It didn't matter. Michigan's statutory rape law is a strict liability crime. That means that all the prosecution had to prove was that Zach and the girl had intercourse. It didn't matter that the girl and her mom went into court to defend him, to say that she was blamed for having tricked Zach. None of it matters in a strict liability crime. So if it were simply deemed an infraction like a speeding ticket, the public wouldn't have cared. What made this case different were the consequences for having been convicted. And having been convicted without really a criminal blameworthiness. Zach faced having to register as a sex offender for 25 years. The public became outraged when it learned that Zach would have to move out of his family home because an underage brother lived there. He had to change from being a computer science major because for the next 5 years he wasn't allowed to own a computer or a smartphone. All because he had sex with somebody he thought was 17. He couldn't go to restaurants that served alcohol, and he couldn't speak to anyone under the age of 17. The public went crazy. The underlying issue was whether it was fair to convict Zach of statutory rape when he didn't know that his partner was underage. The public attached itself to all the consequences that occurred for Zach because of that conviction.